Okay. That didn't work, did it? No, that did not work. It should be streaming now. Fresh. And we'll decide it. Because everything in my life is far too difficult. Yeah, not really. Okie dokie. Don't quite know how that works. Works when I sign in. Sure. Let's go. Constitutional variation determination. When you're doing a university subject, and this is more a broad application than this subject specifically, you have to start with first principles. I tongue-in-cheek a bit back. I get a lot because I deal a lot with people in the community, like practitioners, and you get this constant, continuous barrage of two things. One is, can you get me a job at the uni? Because they hate working in practice. That aside. And the other one is, we don't do enough practical stuff at university. We want to, it's not a practical. Nothing you learn at university is ever going to apply in practice. And I actually had a really good comeback to this the other day. And my generic response has been, well, you've got to start with first principles. You can't learn about the day-to-day mechanical aspects of trust until you actually know fundamentally what a trust is, or contracts, or torts, and things like that. Actually knowing what these things are before you can delve into the minutiae of it. But the response I had the other day was, well, for any person that ever asked me that, they're more than welcome to come and have a look at what a first-year assignment actually looks like in terms of what the starting point is. Or even better, because most of the practitioners are ex-JCU students, I could go back and show them their own first-year assignment and see what it looks like and see what the response is about putting things that are more practical into the curriculum. But nonetheless, I personally felt this subject, when I did it as a student, that there were a bunch of mechanical things that I would have liked to have known. Also, the little bits of mechanical things that have been sort of spread throughout the subject matter that Tom and Nicola both do, I actually think are best to just put into one place. One place where we're talking about the mechanical aspects of how a physical deed document works in terms of trust. Now, you've already heard me mention about the idea of the $10 settlement sum for discretionary trust. It's just the convention that's used. Take a $10 note, you get a third party to be the settlor, and they hand it over. But it might just be worthwhile to sort of know, or at least think about, well, what happens next? And so I'll start with just sort of talking about this idea of constitution. When you're setting up, and here I'm really thinking about express trusts, things in terms of implied trust, constructive trusts and resulting trusts that operate sort of a little bit different in terms of how they're constructed, because they're things where you're trotting off to court to do rather than things you're doing in the day-to-day business of your either legal or other professional practice. And so we use the term constitution to mean the creating of a trust. And the classic line about constitution of a trust is that when the $10 note is handed over, coupled with the three certainties. Remember what the three certainties, the intention, the subject matter, and having ascertainable beneficiaries, a beneficiary principle, either for a charitable purpose or for beneficiaries. And we know all of these little rules because we've talked about them over the last few weeks of this subject. We call this process the constitution of the trust. And that can run into some dramas. And it particularly runs into dramas when people die. Because it's unfortunate that, perhaps it's not unfortunate, we actually think about trusts themselves. Trusts involve property. Must involve property. It's the fundamental difference between trusts or being a trustee, beneficiary, as opposed to all other fiduciary relationships. So tuck that one in the back of your mind. There are other types of fiduciary relationships, but they don't have trust property at their core. You've got to have the stuff. And if we think about this in terms of the context of our lives, assuming that we're not absolutely terrible at saving money, and assuming you're also in Australia because you have a superannuation system, over the course of your life, probably you're going to accumulate more stuff. And so that there's going to be a point in time where you're going to have the peak amount of stuff, or your peak net worth, which is usually for most people that point in time just before they stop working. And so what can happen though, if you need to rush around and organize stuff in your own life, it is not uncommon for this to happen just before people are about to die. And so this can be a little bit morbid. It overlaps, I presume, with what Tony Collins might have taught some of you guys that did succession law. Tony's a local barrister, a very senior barrister who's been teaching succession law years, but here for many, many years. Okay, and so the key thing to note, we've got to have property and it has to be transferred to the trustee. But it's not uncommon, it's not common. It can happen in situations before somebody is about to die, that they've tried to go and move this property across while they're still alive. Because we do make this distinction between trusts that are made while someone's alive, an inter vivos trust, or something which comes into existence that a person's mapped out in their will, a testamentary trust. Okay, and that's might be a helpful thing to tuck in the back of your mind as well. The role of these two people. Settlor, the person who has the stuff, constitutes an inter vivos trust. They're the one who does that. Whereas, strictly speaking, when the person dies, it's the executor, the person who's vested with legal title of all of their stuff, to try and manage it and get it out to the beneficiaries under the will. They are the person that goes and sets up the testamentary trust. That's a trust that comes into an existence, must be mapped out in a will when a person dies. All right, so if you do get, hypothetically examined on the difference between settlors and executors in terms of their job, that's fundamentally what they do. Settlor's job is to give property to the trustee. The executor's job is, where a person dies, take their stuff, distribute it to beneficiaries, or if there are express instructions in a will, to create a trust to set that up as well. Okay, so what happens if you're trying to do a trust and you don't succeed? Now, you guys might have actually studied this with Tina, Corin and Peyton. It was a lady who was, she was married, she'd separated from the husband, and she owned property. I think it might have been his joint tenants, actually. You guys are aware you can sever joint tenancies through the statutory regime. Again, it's got to be clearly expressed with intention in writing. And this is where these things all fall over, of course. Things that have to be in writing, because she wanted to leave the share to her kids, all right, but her share of some real property. And she went about trying to do that. So she demonstrated some intention in terms of doing it, but it didn't get finished. She was dying of cancer before she died. So she died before all of the things that could need to be done were actually done in that situation. And look, equity is supposed to remedy defects in the common law, but sometimes it can be really harsh in terms of things like the requirements of writing. Because if we think about it, if you are signing something, or you're creating a contract, or you've got a document to transfer things, and we know that land has to be in writing, you've got to follow proper procedures in order to get it registered. If you don't reach that final point where it's changed, there's no change of legal ownership. All right. So even though there might be that intention, it hasn't actually transferred. And remember, in trusts, constitution of the trust requires this transfer. And so there are some rules and sort of sub-rules that we need to look at in relation to situations where a person's just about to die and they want to set up a trust, but they haven't gone through and done all of the things to put it in the hands of the trustee. All right, and we call that incomplete constitution of a trust. And so there's a few things here to look at, because the courts, a bit like in contract law, they bend over backwards to find that a contract exists. And in trust law, they kind of bend over backwards to demonstrate or show that a trust exists as well. And in some situations, the courts will mix those two concepts together to try and get to the result that was intended by this settlor just before they died. They jumped through some hoops, some of which can be a little unintuitive, to try and reach that final result. And so the first of these in Olson and Dyson is where a person is about to die, they've got some stuff, and you guys are probably aware that beneficiaries usually are volunteers. And what's the rule with volunteers in equity? Equity does not assist a volunteer. And so by default, an imperfectly completed transfer of legal title is, yeah, sure, you're wanting, the settlor wanted to give their stuff to somebody. They didn't manage to get that far, but that person's a volunteer. They didn't provide consideration. And what the courts have said, in situations where they actually did make some sort of change to their position. I remember, it's probably a long time ago for you guys, your first semester of law school for many of you, you would have talked about estoppel. Estoppel is a doctrine in equity that can arise in a situation where a person doesn't strictly provide consideration to a contract. The other side can be stopped from relying on their strict legal rights. And so the courts can use estoppel in this situation where a representation is made by the settlor, in this case, hey, I'm going to give you your stuff. And the dude who was going to be a volunteer has listened to that statement, materially altered their position as a result. That is estoppel. Okay, and so in those situations, the courts can go and say, well, here is essentially a contract to go through and to do and to move these things. And so as part of doing this, they can go through and use the mechanics of contract law to try and resolve it. Usually get the executor of the will to go through and resolve those things. Because one of the things the executor has to do is to pay the debts of the deceased. So if the courts can magically come into existence this contract by saying, oh yeah, there was actually a estoppel there, then they can actually make an argument that that particular property ought to be transferred across. In those sort of situations. Okay, they can jump through some hoops to try and argue a person. But that estoppel can only arise where some person's going to suffer some sort of detriment. It's not going to assist a pure volunteer where they've done nothing in response to that if the gift has been imperfectly done or transferred. There's also another, this is a little bit quirky. The rule in Strong and Bird applies strictly where the person that the property was going to be conveyed to is also the executor of the will. With the idea being if you promise, for example, you've got the executor of the will, a person dies, say it's the mother, and she has lent money to the son, at arm's length, got it in rule in writing, arm's length transaction. All right. And it would be a little bit odd, and also named him as the executor. It would be a little bit odd for the executor to have to go and sue himself to get that $1,000 back. It was £1,000 in this case. Then the courts have said that's a little bit strange. If she's died before assigning that particular right, or in that case, assigning £1,000 or assigning the particular, the debt itself, either to a third party or back to him. It's a little bit weird if the person is also the executor of the state. Oh, that's a pretty narrow set of circumstances. There's also some rules in succession law. Again, I don't know whether Tony would have talked about these. Where you are like really about to die. So gifts that are made in contemplation of imminent death. By imminent, they mean days, not weeks. Sometimes hours. The courts in those situations can, because they accept, just as the mechanical part of life, that doing things in death is a little bit tricky and complicated. And the courts will take those things into account. They can consider trust to be constructed where there is an imminent, the imminent death of the settlor. I've always found it really interesting going when teaching subjects, going back and looking at stuff that I didn't really understand at the time. And I remember this one in particular because it came up in the semester test, and I remember reading it and going, what the heck is a trust on a promise? I had no idea. So it turns out it's actually kind of similar to that Olsen and Dyson, except in that situation, it's where the settlor has gone and said, I'm going to give you X, Y, and Z. Right? I'm going to go and give you this. And they're going to pay for it. So there is a contract. Now, usually these things are actually done in terms of deeds, in terms of there is valuable consideration. Person's died and before they've actually done the particular gift. And what the courts can say is that, look, strictly speaking, there's no trust. It's been imperfectly created. But because there's consideration here, the consideration of, in this case, the person who's going to get the stuff has to be valuable in some way. And the consideration of the person who's died is the promise to actually make this guy a beneficiary or to gift that property to this potential beneficiary in that case. So they have promised to do something, but they've died before they've actually gone through the actual steps of doing it. Does that make sense? So you know, like Corin and Patton. Oh, hey, I really want to give this to my kids. I'll go and sign the forms. Died before it happens, but I promised to do that. And so that's my consideration into this particular contract. So again, the courts use the mechanics of contract law to resolve this and said that, look, strictly speaking, there might not be a trust, but you can sue contract. This party's consideration was valuable. Here it is. That we're going to pay $10,000, $100,000, whatever it is. This party's contribution was a promise to leave them in the will, which wasn't completed. So they're in breach. They're dead. They're in breach of contract. And so that's how the courts bypass this rule for incomplete construction to try and reach some sort of result as a result. So that's how that works. A little bit quirky, eh? Okay. Writing. Now, strictly speaking, writing is not a requirement for trusts. You just need the three certainties. But in practice, if you're assigning stuff, a whole variety of stuff must be assigned in writing to be valid. It's really where these things have come about. So a variety of stuff. Things like shares need to be moved in writing, intellectual property needs to be moved in writing, real property needs to be moved in writing, motor vehicles need to be moved in writing, so systems of registration. And so you've got the situation where it's like, look, strictly speaking, you can do these things orally. In practice, though, we'd create a deed. A deed is a solemn instrument in law. It's actually governed by statute under the Property Law Act and the Oaths Act that just allows for everything to be put and evidenced in writing, and it must be stamped by a JP. JPs have to go and stamp it. And a deed, importantly in terms of contract law, deeds bypass consideration. And that's a really important point when you're doing things involving equity and volunteers. A deed will bypass consideration. Now, in theory, if we were giving our stuff to a volunteer anyway, provided we met the three certainties, we wouldn't have to worry about this. Well, yeah, you probably won't, but there's a chance that somebody will actually make an argument. And it's really about sort of covering your bases in regards to this. What you'll also find, as I've literally recently found this out this month, is that when you're dealing with third parties, banks, mortgage brokers and so on like that, and the Department of State Revenue, they will insist on there being a deed. And they actually insist on the deed being stamped. What do I mean by stamped? The Office of State Revenue, when you do a conveyance of property, will assess it for duty and they stamp it. That idea of stamp duty. They don't call it stamp duty. They think that's a terrible word. They still call it a duty under the Duties Act. But you can always apply, even for your $10 trust, to get it stamped, which is what I'm doing at the moment. It's $50 or something. I know, I'm getting giggles from somewhere. Oh no, what have I done? Okay, so when you're dealing with third parties, if they want that extra aspect of formality, you take that, your trust deed that you've created, the instrument, you can ask the Office of State Revenue when it's created for the $10 to assess the $10. Now, transferring money actually doesn't attract duty, so they will assess it. You pay them $47, they'll stamp it, say no duty payable third parties sometimes actually appreciate that aspect of formality. Hey, someone else has looked at this. It's been stamped by JP. It's been stamped by the Office of State Revenue. Must be legit. But it's just a practical consideration. Okay. Also note that when I'm talking about the three certainties, sure, we can do these things orally, but in order for a testamentary trust to arise, it must be in a will. So therefore, it must be in writing. It must be in a validly formed will. So that, again, makes this requirement from writing essentially absolute. Okay, and so I've got there equitable property, shows as an action, or many of them, not all. But yes, there are things that require registration. You have to do that in writing. So shares, intellectual property, real property, motor vehicles. I think marine vehicles beyond a certain size. Again, the boating people can probably correct me on that. There's a huge amount of things. In practice, you'd be crazy to not do these things in an instrument. It would probably be crazy not to do it in a deed. All right. Now, a couple of things to note from that, though, and this comes from the Property Law Act, should be. Yeah, I've got the PLA coming up. Now, we've noticed, I think last week I talked about Nelson and Nelson, and that idea of Mrs. Nelson was doing something naughty in relation to getting a second house while she already had one in order to get the Defence Force grant. And one of the points that I made is that when you are creating a trust, an express trust, and those things require, in terms of moving equitable interests of stuff around, got to be in writing. She couldn't do that. It was real property. It was a real property. It was an express trust. Needed to be in writing. She hadn't done it in writing. She'd just given it to her kids. All right. So what that meant is that 11.1c couldn't apply. It just couldn't apply. And so that as a result, 11 sub 2 had to apply. So you can't get an express trust in situations where it's required to be in writing. Courts won't allow that. You have to have an actual instrument. But when you are asking for an implied trust, and I'd have resulting, implied, and constructive. Implied is actually the superset. Implied trust means resulting and or constructive trusts. Not sure whether they've left it broad as a result. Maybe courts will come up with other types, who knows. But it basically, that 11 sub 2 says, this doesn't stop the courts from making constructive trust and resulting trust. Trust by operation of law. That's what Mrs. Nelson had to do in the High Court, and she got up, amazingly. Okay, so those are just mechanical things to note. When you are dealing with third parties, again, you guys are going to be lawyers. You're senior, most of your fourth years now. You're going into the world already knowing a lot more about the rules that govern our society than most others. And so a lot of people will talk about trusts and talk about specifically to terms of a trust that comes on a trust deed. And that's fine. You don't have to disabuse them of that notion. Fine. Strictly speaking, it's not needed, but it's crazy not to. I'll leave it at that. Right. So, you've got a trust and you want to change it. I've only got one slide on this. But we call this the variation of a trust. And trying to get the courts to do this in their equitable jurisdiction is nigh impossible. In the equitable jurisdiction, they can't do very much at all in relation to this. Okay, the courts, they've said for a long time, look, we're the ones that determine whether the trust exists, and we're the ones who are the arbiters of whether trusts have been administered correctly, but the content of it is outside our scope. It's much like courts in terms of contract law. Don't look at the underlying fairness of the bargain. They're not going to try and move consideration around. It's fundamentally not what they do. And here the courts have said the same thing. But Parliament's jumped in on that one and said, yes, you can and you will from time to time when you need to. Because the key idea is that, look, from time to time you are actually going to have to move things, particularly for people like minors. to actually move interests around. It does happen occasionally. And the rule, generally speaking, is that you can do that and move beneficial interests when it's not going to change the beneficial interests of the other beneficiaries. So if there's $1 million in a trust and there's 4 beneficiaries, changing the fractions must influence or affect the other beneficiaries. Right? It has to do, and the courts are very reluctant to do that. And so that they, when they're going in varying matters, they get powers under the Trust Act to actually go through and change things, change the trustees, change how these things are paid out, change how these things, but they can't change the fractions, the percentages, or at least they can't do it if it's going to cause detriment to the other beneficiaries. They can find other ways around it. So, for example, moving some things around so to get, I don't know, some sort of tax benefit or advantage over here, or the court creates some other order where they're going to get some benefit that's going to go back into it. One beneficiary could have their share enlarged, provided it doesn't impact the others. That's a starting point for that. The other main way, by the way, of changing the trust instrument is in the instrument itself. We looked at that deed in the first tute. It has some things there saying this deed can be changed if X, Y, and Z happens. I can't remember what it says, but it does have some in there. That's fine. The instrument can change itself. Can't obviously override the intent, clearly expressed intent of Parliament or the common law, rules of common law and equity. But the statutory framework in the Trust Act also gives scope. Trust Act's 1973, isn't it? I put the wrong year. Not sure. The statutory framework, oddly, in Queensland gives massive powers to the courts to change stuff. And it sits alone, oddly. I don't know why. There you go, research task. Go and find out what the intent of the Queensland Parliament was to give the Supreme Court of Queensland the power to change trusts, even where inconsistent with the instrument itself. So just make note that in Queensland we can do this, in other states they can't. Powers of the court can't change the instrument to make things inconsistent with the instrument itself, unless the instrument itself is contrary to law in the first place. Oh, we can have 10 trustees in this express discretion trust. No, you can't. You get 4. Does that kind of make sense? Like that? So I don't know why. Trust law is not uniform. It's one of those areas. You guys, some of you guys doing evidence at the moment. They talk about the Uniform Evidence Act. They're not uniform. The Australian Consumer Law is uniform, but a whole bunch of other things aren't. So like Goods Act, so the evidence rules, the criminal law, that's not at all uniform. And even where they've tried for some regimes, Civil Liabilities Act, you find what gets in the way? Politics gets in the way. And then you get particular pressure groups that are bigger and stronger in some states will get things changed and moved out. And so the federal government's trying to make things uniform, but things change over time. Politics and democracies is not perfect. Okay. Determination. I don't know why they use the word determination. It's also termination. All right. And the key thing to note, I don't know if I've explained, but I need to tell you right now, it's a really important rule. It's the rule in Saunders and Vautier. And it goes like this. A sui juris solo beneficiary who is not under a legal disability, so usually an adult and not bankrupt, can demand all of the property and the current income or future income, whatever, assigned and unassigned income, and end the trust. Does that make sense? I can't hear me. Say it again. The rule in Saunders and Vautier says a sole beneficiary, and this can be in discretionary or a fixed trust, doesn't matter, who is presently entitled to the income and the capital of that trust, who is sui juris over the age of 18 and not under a legal disability, can demand all of the stuff and end the trust. And for all of those in this room, and I'm sure there is a non-trivial number of you here, who are the beneficiaries of family trusts, if you are the sole beneficiary of that family trust, you might want to know this piece of information.
Gina Reinhardt didn't know that. I don't know how Gina didn't know this piece of information, but if you have a clause in the deed that says the stuff won't pass until this person reaches the age of 30, guess what? Roland Sorters of Ortia says, I think in that deed it actually said you had to be 21. Oh, 21? 25. And the person who was younger than that demanded it, and they said, yeah, you're the beneficiary. Yeah, it's your right to go and ask for that. Now, there are some restrictions on that, like all of these sorts of rules. But that is the starting point for the determination of trusts. You can demand your stuff. You're the beneficial interest holder. Yep. Bankruptcy. So an undischarged bankrupt is one. A person who's under a power of attorney is another. A person who's under an involuntary treatment order is a third. I can think of some more obscure ones. A person who's been declared dead and then turns out to not be dead. Those are some examples. Okay. And this is extended in situations where all the beneficiaries are sui juris, not under a legal disability, and come together and say, we want to end this trust. We would like our stuff, please. And the fractions that either are in the instrument for a fixed trust or in fractions that we have come together to agree about. And this is an interesting point. If they don't agree, what would the fractions be? Oh, we think, we tenancy in common, section 35 of the PLA. No, because if they don't agree, the rule in Gosling doesn't apply. They didn't agree. They have to agree when they come together to end the trust. They can do that collectively. So, what happens in situations where you've got one beneficiary who wants out? That's where things get a little bit more complex. I'm not writing the assessment for this subject, but this is the sort of thing that in practical considerations would be a very useful task. And it's the rule in Whakatane paper mills. That's one thing about being a Kiwi is you get to pronounce all these words right. And sometimes I've listened to some of the other lecturers pronounce Māori words and go, it just makes me wince. And it goes like this. One beneficiary can ask for their share. All right? Again, if they are sui juris, not under a legal disability, and allowed it. All right, allowed it. Now, they can demand it, but they can only get it if the property is fungible. This is Jamie's favourite word when we were talking about, I think land law. Fungible property is a blob of stuff where each component of that stuff is indistinguishable from the other components of that stuff. What do I mean by that? The petrol in your car. 1 litre of petrol of your car is not really different from any other litre of petrol in your car. They are fungible things. 10,000 tons of wheat is a fungible. You can split that up easily into 2 5,000 tons of wheat things. That is a fungible thing. Have you guys heard that word before? I don't know. Chris may or may not have mentioned it. So anyway, if the stuff can be split, then it can be done. That's a practical consideration. And again, this split has to be done without prejudicing the other beneficiaries. That is why real property can't be split. In most situations, can't be split. Even if you could actually go to the Lands Titles Office and say, oh look, there's 300 acres and 3 beneficiaries, 100, 100, 100, let's do it. Why? Remember the rule for specific performance in contract law? What's a defining feature of land? It enables you to get specific performance in contract law. It is every packet of land is considered to be unique. So in that situation, you would need the other beneficiaries to come together and let you do it. You won't be able to do it by right. These are really important considerations in practice. By the way, I know that it's difficult for these things, and again, we're supposed to make things more authentic, but it's difficult because these rules aren't actually that complex, and so there's only one slide. only one slide on this. And so, but in practical terms, it's going to come up a lot more than somebody, dying and doing a trust or whatever the rule, or the executor, the strong and bird, cases like that won't come up. This stuff will come up more often when people want their stuff. Okay, what have we got time? Fine. Avoidance. Talked a little bit about this idea of the settler doing takesy-backsies. Not usually themselves doing takesy-backsies. It's often the liquidator and or the trustees in bankruptcy wanting to basically go back and undo transactions involving the settlor. But from a starting point, when a settlor, in an abstract sense, gives their stuff away, by default, you're not going to get it back. It's one of the fundamental things about allocating it to the trustee. The trustee has legal title. But we know that there are naughty people in this world. And so all of those doctrines that we did in contract law, the vitiating factors, they can apply where a settlor has, somebody's gone to the settlor and said, create this trust or I'll break your kneecaps. Or create this trust and I'll look after you for the rest of your life. Create this trust or I won't love you anymore. Create this trust and I'll bring you some heroin because I know you love it so much. What's another one? Mistake. I'd have to think of a more obscure example with mistake. Create this trust over this nephew, but I meant this other nephew. Somehow they were twins. I don't know. No, that's not a good one. But nonetheless, all the vitiating factors of contract law will apply and can apply. The elements are going to be exactly the same, and you would argue in exactly the same situation. And that was one of the things that they tried in Orchard and Skinner. I don't know if you guys remember that case from contract law. It was the undue influence case. Religious advisor and follower. She took 7 years. She decided, went off to be a nun, gave her stuff to them. Then they came back and they tried to argue this, that she didn't really do this as a settler to trust, and they turned out and said, yeah, maybe, and you might have got up if you didn't take 7 years to try and, to rock up to court. It took too long. Now, while in common law, or in equity, I should say, when you're giving stuff away, 3 certainties applies, don't need things to be in writing. In practice, we do things in deeds, and deeds can actually have clauses in them that say, in some situations, the stuff will be sent back to the settlor. What's some problems with this? Well, if such a clause exists, the courts member can construe these clauses as actually giving the settlor a beneficial interest. All right, and that's going to be extremely problematic. It is most problematic in terms of tax law. Truesdale's case, I've mentioned earlier in this course, but I talked about it for those I taught tax. Truesdale's case happened when they changed the anti-avoidance rules in the old Tax Act to say, there you go, Section 102 in the old Tax Act, to say that if there's a closely held settlor trustee beneficiary relationship, got to pay tax at 47.5 cents to the dollar. Too bad. Too close. That's an anti-avoidance mechanism. And of course the Barwick court jumped in and said, oh, well, Parliament, you used the word settlor here. So if someone else is the settlor for $10, that's going to be fine. And it is fine. And as a practical consideration, that's why you get your accountant to be the settlor on your trust. And you do not have a reversionary clause in there giving them this ability to get the stuff back. All right. And another thing to note is that if there is a reversion clause, it's a beneficial interest. And that beneficial interest will or can give procedural rights to the liquidator or to the trustee in bankruptcy. And they can then demand the trust repay it. So if the clause in a trust deed says, in some circumstances, this stuff can go back to the settlor, when you become bankrupt or it's a company we're thinking about and they become insolvent, though the people that take over, the trustee in bankruptcy or the liquidator, can step in now that they hold the mere equity on behalf of the person who's now under the legal disability. They can step in and demand the stuff, or at least they can try. These things end up being expensive because it requires you to go to court, because the court has to interpret the clause. They've got to go through the clause and work out, oh, can the settlor get this back or not? I don't know. I have to read it in a certain way. The key thing from you guys to know, don't put these things in trust deeds. You'd be crazy to do it. And Tom always says tongue-in-cheek, oh, I need to tell you this so that when you go into practice, you don't get sued in negligence by beneficiaries that are losing their interest left, right, and centre. Okay, and there is actually another situation. I've put the bankruptcy ones up here. I didn't put the equivalents in the Corporations Act. I don't know them off the top of my head. I think I might put them in the first slides, possibly in the first week. We talk about avoidable preferences, transactions that can be undone by either the liquidator or the trustee in bankruptcy, because they happened close to the point in time when a person went bankrupt or went into liquidation. And the statutory power to undo stuff. I didn't realize it was 5 years for bankruptcy, which is huge. I had no idea until I went and looked at that. I was horrified, actually. That's quite a long time. That is quite a long time. Okay, and just make note that it's got broad scope. If the main purpose is defeat or to hinder potential future creditors. And there is an equivalent in the Family Law Act. So if you are moving stuff around because you know there is a pending family law property settlement, it's likely to come up. You know, if your husband or wife has just said they're leaving you, and then you immediately call up the trustee and say, "Oh, move this stuff out to a subtrust," which is exactly what Spry QC did in the case of Kennan and Spry. Wife says she's going to leave him, calls the trustee up, who's his good friend, and says, "Oi, move all the stuff to a different trust." Yep.
Would it make a difference if they instructed to do that before?
Yeah, it'd make a huge difference if you didn't know about it. There's obviously got evidential things, but I mean, from a practical consideration, being told that you want out of a marriage doesn't usually come in a vacuum. It's usually not a surprise, you know, deep down to most of us, how and where these things come up. Yeah, so many people, young people in this room with such amazing things to look forward to in life. Okay, last slide of this one, and then we'll take a break and then flick over. It's just to do with perpetuities. Actually, I mirror it in the I mirror this in the next one because we're going to start talking about charitable stuff anyway. But I've mentioned this a few times that trusts follow the normal rules for perpetuities. And Queensland's mapped out by Parliament. We teach the common law rules because we teach the common law rules for everything. I don't know why in this particular one. And so just follow that. It's 80 years and it's wait and see. What that means is that if it looks like something might not vest, we're still going to wait. We're still going to wait. If it's manifestly impossible for it to vest, that's fine. We will then end it, revert it back to the settlor, usually, or find some other mechanism. But if it could vest, we will wait it out for 80 years. The deed that the trust deed we did in shoot 1 would have had a clause in it, and it said this must vest before 3rd of August 2099 or something like that, and that's fine. All of those things are fine, but 2099 sounds like a really long way away. Okay, just make note, charitable trusts don't have that. So the CRA, they said that there was a gift, I think it was for 200 years, and they said that's fine. It's fine. For when you're doing good in the community, we don't care how long that those funds are held. If they're going out doing good things in the world, don't care. So charitable trusts are exempt from that. And from memory, yes. That's going to be the end of this session. And we're going to be starting the next one. So we'll give me about 7 or 8 minutes to change the things over and get some water and some bits and pieces. And we'll be back in a second.